You're pretty busy, right? Yeah. So how is the new place? Do you like it there?
It's good, yeah.
You've been having fucking months already, right?
Yeah. Yeah,
That's
like
good, you look
three.
good.
Thank you.
How are you doing? I haven't seen you in a long time. I'm like the very thing. Oh, really? I was supposed to do an interview, then I went back to another country. I didn't have the time to. That's good. How is it? Do you like it there? I am so happy. So what do you guys do?
We're the buyer specialist right now. We're not doing this mostly.
So what happened? They give you the buyer, you throw it, or
We
you
have like a, yeah, we have like a, what do you call this? We need something and then it goes to us and then that's our job.
So you
Follow
talk-
up on that.
and did you get buyers or they?
We do, yeah, we do get buyers from it, but it's up to us how to follow it up.
So how is it going?
It's great. And then, if I have a listing,
Yeah.
I just, funnel it through them and they'll do it. Because
They
we have a
have
listing and then we have buyers. Right
So-
now, we're being trained as buyers.
buyers and listing, they have it.
Yeah, yes,
So how was it like? How what percentage?
yes, it's 50.
Whatever, I see, okay. So whatever, if you get something that's 50%.
What about you? What are
I'm
you?
doing myself, I have been, actually, I was about to, actually, you told me about it, and then when the day I was supposed to have an interview about it. 1 minute, all of a sudden, I had a family emergency in the country. So I went to Bangladesh. So then I was not here, so that's the, that is the point where I think that thing. That's okay, that's good, I mean, that's whatever happened, whatever not supposed to be, not supposed to be. I was supposed
Well,
to-
I'm glad you're still here. That's good.
Yeah.
I know some people, they.
I don't think I'm here.
Did you go get the paper?
Is this the for contract?
You take one already. Is Lucy back? Not yet.
Oh, it's another thing I want to know.
Yeah.
Should I contact because I have someone who's interested in the religion. And he wants to take classes. I know. She is with his. Should I talk?
I would talk to Angie about it. And she's kind of taking over some of.
Okay, so I know somebody who's interested right now.
Right, awesome, yeah, we would love to hear from them, so.
Maybe
After.
I'll talk to Angie. Thank you so much.
I'm doing well. How are you?
I'm doing good, thank you so much.
Yeah. Hey, how are you doing?
No, but Remind me of my brother,
What?
like you. My brother has to have Coke every day since
yeah.
he's a little boy.
I got cook.
Really?
Oh, since I was 5 years old.
Really? Oh my God.
Oh, yeah.
You notice the difference in the taste between the Coca-Cola back in like the eighties and seventies? Yeah.
Was that better?
Oh, yeah.
I think that was
Much better.
pure sugar, right?
You know, the,
Sugars are different, right? Do you want me to help you with that?
Back when,
Let me.
in the bottle of Coke,
Yeah,
the glass bottle of Coke.
Yeah.
Just those.
it is like
Of
that.
course, you remember things like that, and
Mhm.
it's hardly ever what you remember it as.
And I remember just back in my country, that's some common thing, now we have this, but that was very common, glass things,
Oh, yeah. They still make them in the glass.
Yeah,
They do.
actually,
It's like you can actually get your custom name like engraved in it. That's.
Really?
Yeah.
It just costs money.
That for my, well, did that for his wife's anniversary, so. It's actually pretty cool. I didn't even know you could do that, like.
actually, I think in Mexico, they have, from Mexico, then comes, they have like with pure sugar. Because a lot of people, they don't let the children have those, so have pure sugar instead that. I think they are glass bottle. A little more expensive than with sugar, I think.
Yeah. Use the old
Like they
recipe.
bring, yeah, it's in, yeah.
Okay.
Always the one that was asking. if I can use, Our business, so that I could get into it,
Can you do what?
the business entity that I've had. We spoke before. I need to apply for that, so instead of me getting paid under my name, I'm gonna use that company.
You have to go through
Yeah,
the process
yeah,
with
yeah.
Shrek.
So something changed, that's why I didn't do it, I just wanna ask you, was you going to do with that?
Hey.
Haven't seen you in a while.
I think changed, right? Just, or do I need to put them in there?
Yeah, if you want it, no, just you want it in your LLC,
Yes, yes, yes,
then you have to go through the process with Shrek.
That's-
So the LLC becomes a broker.
okay.
Yeah.
Yeah, because I gave you the paperwork already and.
Yeah, it's just the only change is gonna be. How we doing? We got our Zoomers up?
Yeah, it's already connected. Did you want that fish plate?
Well, can we do that? And let Shelby do Zoomer?
Slow like this.
Yeah.
5 years.
Kind of combine it. The only thing is different is the source of your money through the very team or wherever you're gonna get it. Because you can have it go to, yeah. So you just have to set that up with Trek, go through that process for a Trek website, where it talks about, license, real estate, entity broker, and then go through that.
So I don't have to change anything on that paperwork.
Yeah.
So they guys like.
You're gonna go with the very team.
Of course.
Because they can be involved in your LLC. with it.
Okay, perfect. So now I can. Thank you.
She's getting hustled out of the.
Yeah,
It's a buying.
they were like, sign up for the free program. And so they'll see.
Oh, yeah, good.
And then this, I can get this,
Sure. Yeah, great.
On sale too.
and I can make this bar go.
How many do we have so far? One?
Yeah, 1, 2, 3,
Yeah.
4, 5, 6.
Okay. Great. Super. Everybody has the material?
Yes.
Oh,
Good. Send back. Hoping you got it because I can get it clear to the next time. So. So the concept of what we're talking about. Don't worry about that. Deals with your role in the contract and making sure your client understands what everybody's agreed to. Now, the thing we have to keep in mind is everything in the contract has been mutually agreed to by the buyer and the seller. And they don't really read through everything and really understand what they've agreed to. They kind of trust their agent to do that. And so as we go through that, it's very, very important that while we're not a party to the contract, we understand what both parties have agreed to, especially as we protect our client as we go through that process. So what we're looking at are the various termination rights in the contract. We want to.
Chris.
Okay. Good. So we're looking at all the terminations in the contract and understanding what's been agreed to and what's in there. There are two types of termination. One, there are termination rights that a party has as a result of the terms of the contract or addendum. And then there are some terms of the contract that in and of themselves causes the contract to terminate. We'll look at both of those as you work through it. So on the handout, you've got we've got the concept of it. And you know what I just said, it gives parties a right to terminate the contract. And then terms of it that if not resolved, will terminate it. Now, the follow-up concept of this is we need to make a distinction between a right to terminate and an obligation. Oh, right.
Can you start over? Sorry.
Absolutely, not a problem. I was being careful
Papers on.
not to say anything important until you got here. And you all would agree so far, nothing important has been said, so we're good. Don't agree to it too aggressively, so. So, when you have a right, it does not confer an obligation, and yet we tend to pull those together. And I give you an example here of the option period. So think about the option period, which we'll talk about a little further in the handout here. But if the buyer chooses to exercise their right to terminate during the option period, there are certain steps, certain things that have to be done. One of the things you've got in your package, the last 2 pages, deals with the forms of the buyer's notice of termination and the seller's notice of termination. Those are both contract forms. But if the buyer chooses to exercise their rights during the option period, sort of like that. But let's think about the case in which a buyer may not choose to exercise their right to terminate during the option period. What's the consequence of that?
Option, they have to go through the contract.
Well, maybe
And they have other things as well that.
they may. Look at the classic concept of a contract that's a cash transaction. It's not in a major HOA. Maybe the seller is a trustee, which means there's no seller's disclosure notice. Maybe the only generally a right of termination may be the option period. And so it may be the case that if the buyer does not exercise their right to terminate during the option, they may have no other rights. And we're going to see as we look at other things that in some cases there are. But in that case, it's significant that the agent makes sure the buyer understands once we pass this timeline in this transaction, that may be your only right to terminate the contract. This may be your only way out. And the follow-up to that conversation is they need to consider how much they're willing to put their earnest money at risk. Because the whole concept of, or not the whole, but an important concept of termination is what happens to the earnest money. If you have a right to terminate, then you generally would have a right to the earnest money. So it's an important consequence that if you don't exercise it, buyer needs to know what else could happen. We'll see, especially when we get to some of the addenda, like the sale of the property addendum, some other addendums, the major HOA addendum, where there are certain rights to terminate there. So it may be that the buyer says, well, I just couldn't get everything done during the 5-day option period. I need more time to negotiate repairs, and the seller won't give me more time to extend the option. But fortunately, I have other rights termination. And as a result of that, the buyer says, I'm not as much at risk if I've got financing, if I'm in a mandatory HOA, if I've got a sale of the property addendum. So you're the one that has that big picture. You're the one that looks at this and says, yeah. Buyer needs to know when he makes a decision about any right of termination, what's the consequence? Where is he now in the terms of the contract? That takes your understanding as we go through this of all the other rights and what's going on in the contract itself. So consequences of what it means and what it doesn't mean when someone, in fact, passes up a termination period. Then, in fact, what you should do to your client, particularly to the buyer, because most of these are related to the buyer, is that before that timeline passes, you need to send an email to your buyer. You say the option period ends at 5 p.m. today, and you just need to know that after that, this specific right of termination may be gone. Well, will be gone. It's gone. We'll look at when we get down to the termination rights in the contract, and the first one we look at is the right to terminate based on the option period, termination option. We'll see that there are some things that happen in the marketplace, some culture things that we've got to be prepared. By culture, I don't mean national origin, I mean the culture of how we do real estate. And we find that and as I interact with brokers and people around the state, other states have entirely different cultures, different ways of doing things as they work through it. So let's look at this first thing, the termination rights in the contract. So you see on page 2 of the 1-to-4 family contract, you see in 5B, that's the unrestricted right to terminate the contract until 5 p.m. on the last day of the option period. Be sure Sally can get some material in the back. Work through it. I know. Try to sneak in, but no way to do it. Okay, so first question I have of you is on this termination option. What does it mean, unrestricted right to terminate?
If they change their mind.
If
Prior.
they change their mind, what?
For any reason, they just don't.
Okay, are there other termination rights that you can terminate for any reason? Sure there are.
Yeah.
7B2, self-disclosure notice, A1, major HOA. Those are any reason rights to terminate,
Or they didn't.
but they're not unrestricted. Why is this the only unrestricted right to terminate?
Because those other rights terminate, there has to be a condition met for it to be to terminate it. Under this one, there does not have to be any condition met. Because you're paying for it.
That's the key. You pay for the termination option. That's why it's unrestricted. So we're on the first page of the handout, page 2 of the contract, look at paragraph 5.
Thank you.
So the key is it's unrestricted because you pay, buyer paid for it. The others are based on the receipt or non-receipt of information. So self-disclosure notice 7B2 is based on receipt of that. A1 in the major HOA is based on receipt of that information. So this is unrestricted because now, what does it mean if the buyer chooses to not exercise this option?
They're gonna have to go through with it.
Well, they may.
Yeah.
There might be other rights. Here's your big challenge with the termination option and the option period. This gets into the culture of how we do real estate, how we do real estate in a particular market. There's a tendency, in fact, when you've got a listing and your seller is going to accept an offer into a contract, you're going to educate your seller. Say, okay, here's how this works. The buyer has paid $200 for an option period, and he's got 7 days. In that 7 days, he's going to do inspections. And we expect we'll get something from them as you're going to start negotiating repairs. And that's, that's kind of the norm, and this is how this works. So you're going to educate your seller about how that works. What happens is it goes beyond that. There's the belief by a large number of people in the business that that's the only time you can negotiate repairs is during the option period. And if the buyer doesn't exercise his right to terminate, if the buyer just lets this option period lapse, he's given up his right to negotiate repairs. Is that true? Absolutely not.
No.
The buyer can negotiate repairs all the way to closing. It's just they have a lot of leverage during the option period. But this is so expected to the point that, in fact, sometimes a buyer will make an offer and will not have an option period at all in the offer. And seller, listing agent may say, oh man, that's a great offer. They're really committed. They don't even have a right to terminate. They don't even have that termination option. And that's just not true. In fact, it may be better for the seller that the buyer has that right of termination, because one, he gets money for it. Seller gets some money. You work through that process. So it may be one of those things that's actually better. Plus, it tends to, in some way, compartmentalize when the buyers expect to do certain things. Because not only is the listing side expecting this to happen during the option period, so is the buyer side. Buyer's agent say, okay, this is why we do inspections right off. We're going to just first thing, because that's when you have the biggest right and the most leverage right of termination. And that's true, although, as we talked about before, we'll see others in here, such as the mandatory HOA, A1 in that, and we'll look at that addendum later, and we'll see there's something in A2 and A3 of that same addendum. If you got 7B2 that goes live in the contract, self-disclosure, buyer's right to terminate for any reason, not a reason specific to what's in the self-disclosure notice, but they just got to pay more instead of our high house. Have a right to get out of it. So as we work through it, while there are other rights of termination, as we'll look at, we'll see here, the custom is we all expect to do it. Joe?
Do the other rights of termination protect the earnest money for the buyer?
Do what?
Does the?
Other rights of termination, yeah. And all the other rights of termination, it has language in there, just like with the buyer approval and third party financing, property approval. It has language in there that says earnest money is refunded to buyer. Now, having said that, virtually all the title companies on all the other rights of termination will require everyone to sign off. The only right of termination that most title companies won't require both sides to sign is the termination option in paragraph 5. So you've got a little bit of a challenge if you're terminating their buyer approval or terminating their HOA, then the seller may get his nose out of joint and say, you know what, that's just not right. You're just pulling the, thing here and we're not signing anything. So while the language is there, the custom is you may get a battle with the seller. You work through that, and often do, especially on buyer, because and we'll talk about that when we get to the third party financing. But the real key here in dealing with paragraph 5 of the termination option is what's expected, and so you look for those little red flags from on the other side, whoever that might be. Joe.
So in that case where the seller objects and says, oh, we're not signing anything, it's a bad deal, what's that? Isn't it can't sell the house, right? I mean, it's got to be clear.
Not all the attorneys agree on that. Most attorneys says, yeah, if you don't resolve the earnest money, you really shouldn't enter into another contract. It's really not a good idea because you've got a primary contract still sitting there. Because remember, if it doesn't close on the day of closing, it doesn't die. It continues for a reasonable time, and we don't know how long that is, but it continues as you work through it. So it does get to be a little bit of a challenge. They shouldn't as you work through it. Now, your challenge as you work through it is what the title company is going to require. But we need to help our client understand when we get into this battle over earnest money, they need to understand we don't have it. And we don't have any control over it. title company is the one who has the earnest money. So they'll determine what has to be done for that earnest money to be released. Anna?
One of the title companies told me that they will wait 30 days. And if the seller still hasn't signed, they have to send the seller a letter for the release to be signed. And if they still don't sign it, then they can release it to the buyer.
Okay, but there is a paragraph 18C. And the timeline is actually 15 days in the contract. Depends a little bit on the title company, whether they'll do it 15 or 30. But the language, paragraph 18C of the contract, and you've got a copy of the contract right there. It establishes a timeline that if one party makes a request for the release of the earnest money, and if after 15 days, there's no objection, written objection from the other side, then the title company can release the earnest money with just that one set of signatures. Now, that language in 18C came from the title companies. I served on broker lawyer committee. The title company said, yeah, we're willing to do that. Not all title companies do. Many title companies are incredibly protective and say, well, somebody's going to sue us if we unreasonably release the earnest money, and we're going to have a problem the other side. But at least that creates a mechanism you just talked about so that they can, in fact, release it with just one set of signatures.
But the language here says escrow agent may disperse.
Yep, that's correct. It doesn't have to, it's not required to.
Yeah.
And so it's an important point that Jenna brings up. This again gets to the policy of the title company and what they're willing to do. When we get to the addendum for the sale of other property by buyer, we'll discover that automatic termination in there. Both title companies will not require the other side to sign. Most is probably too strong. Many title companies won't. Republic, for example, they'll release it with just the buyer signatures. Because it's an automatic termination. And we'll get that, we'll get to that addendum. But it's really important for us to understand that the whole earnest money issue, we want to protect our clients' earnest money to the degree that we can. Making sure they understand we have no control over it. Any earnest money dispute is between the buyer and the seller and kind of the title company because of their policy. And well, here's what it is. And they kind of use an excuse. Well, you know, we're a neutral third party and takes part of insurance, kind of puts us in that position. Yes, sir.
So all right, since this is the legal contract that they agreed to, and this 18C has this language in it, does this not trump the title company's policy?
No, because as Janet pointed out, it says may. It doesn't say must.
If it had said must, then the title company would have had to follow this.
You know what?
Never mind.
Here's why the title company doesn't have to follow what's in the contract. Look at paragraph 18A. Title company is the only non-party to the contract that in the contract states that. Which means they absolutely have no liability, no requirement, nothing to do anything that's already agreed to in a contract.
But I think 18 or whatever D damages needs to be understood as well as C.
Yeah, we worked hard on 18D. We used to have better language in there than we have now. And there was one particular court down in Houston that gave us grief that really helped us not be able to do it. But in 18D damages, we used to have in there an automatic triple damages, which really created some leverage that if you didn't release the earnest money, that you were liable for 3 times the amount of the earnest money, court costs, and attorney's fees. Now, one of our challenges is that when you have the very first part of the sentence in 18D, says any party who wrongfully fails or refuses to sign a release. We couldn't come up with a good definition for what wrongfully refuses means. So while it's a good thing and it gives a little bit of leverage, and where typically most of the time an earnest money dispute goes to small claims court. If it's 10,000 or less, it's a small claims court, and you'd make use of these terms in the contract to try to make the case as you work. Remember, in a small claims court, you're dealing with the experience of the JP, and you don't have to be an attorney to be a JP in a court, justice peace court. And so whatever their experiences are, it's kind of what you're living and dying with. It's kind of a flip of the coin, despite the fact you've got some good language in the contract kind of help you out as you work through it. But those are, you know, the big thing as you go through this is help your client understand that you understand what the contract says, you understand the process, but you have no control over the earnest money. Makes semi-sense. And you do it in a very rapport building, user-friendly manner, because you don't want them to feel like you just, hey, it's not my table, sorry, can't help you. No, how many times we don't have honey mustard, stop asking. If you just, you want to support them and say, you know, here's what the contract says, and here's what a non-party, i.e. the title company who has the earnest money, here's what we have to live and die with. And understand, it's just like when you have that classic situation that your buyer's writing the offer and they're gonna have 5,000 earnest money and they write the check, 5,000 earnest money to the title company. Sometimes your buyer will look at you and say, now, I want to make sure I understand this. If I don't get loan approval, I get my 5,000 back, right? If I don't get approved for a loan, if I can't buy this property because I don't get approved for a loan, I get my 5,000 back, right? What do you say?
If it's,
What do you say? Do they? No. Oh. Not necessarily. But what their little person, well, I want to make sure I understand what things in the contract put my earnest money at risk. I want to understand what's going on there. You say, well, there are actually three things that are involved in the release of earnest. One is what the contract says. And under property approval, paragraph 2B, a third party finance addendum, if you follow the instruction there with a timeline, property approval, not buyer approval, property approval. And it says buyer gets earnest money. So there are a number of things. In fact, virtually every right of termination addressed in the contract and the addendum have the language saying an earnest money regarded to buyer. So the contract says, yeah, you get your earnest money back. So that's one important thing. The second is the actions of the parties. Let's say that the buyer is going to terminate under buyer approval in paragraph 2A of the third party finance addendum. And the seller said, whoa, what are you pulling here? We had 5 offers. We had 3 of them that were really, really close. The reason we took your offer is because you just absolutely sold us on how qualified we were financially. You know, we talked to your lender and they said, oh, solid gold. This guy's a Hall of Fame for barbers. He's great. And so the reason we took your offer is because you convinced us that you were approved. This was a good deal. And now you're trying to get out of the contract because you're saying you don't have buyer approval. Did you just lie to us before? What's going on here? Because remember, nowhere in the contract, except on the first page of third party finance in paragraph G, where we now actually name a lender, when a buyer is under a conventional loan and they start with this lender and this lender says great things about them. And then during the course of the contract, the buyer changes to another lender, which they can do. There's nothing in the contract that restricts that. And so now they've got another lender and the other lender says, well, I don't know if we can do this right. I said, well, then I'm going to terminate the contract. And as long as it does it within the number of days and 2A buyer approval, he do it. And the language is that he gets his earnest money back. But seller said, I don't think so. So said, I'm not only not signing anything, we're suing you. So the actions of the parties. First, what's the contract say? Second, the actions of the parties. The third is the policy of the title company who has the earnest money. And their policy is this is not going anywhere until everybody signs a release. Then their policy is what really determines if an earnest money gets released. And your client needs to understand, here are the 3 things, the 3 factors involved, and you having the earnest money released. And you just need to have a sense of those 3 things. And the key is you have no part in any of those 3. I mean, what's in the contract? You know what's in the contract because you understand the contract, you've read it. The actions of the parties are going to happen at the time. You have no control over that. And of course, you have no control over the title company and their policies for releasing that. Questions on that? That makes semi-sense?
Is there any way to protect our sellers?
In what way?
Should we be asking the question of the buyer's agents? Is this the company? Is this the loan company your buyer intends to close?
And this is the thing that keeps coming up and people say, isn't there some way that we can have something in the contract where the buyer has to use, they name a lender, they have to use that lender, and they can't change lenders during the term of the contract. It's just like, a seller can't enter into a lease or anything or do anything, use the property once you're in a contract. Is there some way to do it? Well, it'd have to be attorney prepared language. To do it, it could be something that the parties do. And it would be hard to come back, because what you're doing is you're restricting the buyer. As long as the buyer at closing shows up with the money and closes, doesn't matter what lender does, does it? It's what it is. But many times we'll find a seller saying, you know what? The reason you need another extension on the closing date is just 5 days ago, you just switched to another lender for, an 8 to a point or something like that. That's just wrong.
A lot of these people use online,
Yeah,
people to get pre-approved. And
Yep.
then we put them up with a local lender or somebody else and who says, there's no way they can.
Yeah, uh-huh. The buyer keeps shifting to the lender of the day.
So I see some listings where they're saying buyer must be pre-qualified or whatever
Sure.
with this lender. Even though they don't have to use the lender all the way.
You
through.
can have a situation, for example, where a seller can require a lender the seller is comfortable with to pre-approve the buyer. And they're not going to require the buyer to use that lender, but a lender the seller feels good about is going to say, yeah, this person is qualified. If they were going to work with us, we could do that. So, and you'll see that in MLS. You'll see where, seller requires a pre-qualification or pre-approval by their lender, by a lender they're comfortable with or one that their agent's comfortable with. So they can do that. You just can't require them to use that lender. That's a good step for a seller to make sure you've done that. Yeah. There are other things that really, again, become attorney prepared language. The seller say, within 5 days or 10 days or whatever effective contract, the buyer must produce a clear to close, an approval from a lender as it works through the process. So the seller will take extra steps to make sure they don't give that buyer the easy out under paragraph 2A of the third party financing addendum, which is the buyer approval. Seller go through that. And if the seller's in a multiple offer, they're in a better position to do that. Good sense? We're walking the fine line here, and it comes down to your knowledge of the contract and all the things that could happen, and who the parties and the non-parties to the contract, what kind of control they have, or what happens, particularly in earnest money. Because you don't want it to be all of a sudden a big surprise to your clients, because they're going to terminate this deal, and they need that $5,000 earnest money back to go into the next house. And then they find out that's not going to happen. Here's why. And now as you're helping educate your client, you've got to make the judgment call on how they process information. Because if you go too far, you're going to make them paranoid where they can't make any decision because there are too many possibilities, too many bad things could happen. And they begin to blame you on coming up with all these problems. So you've got to make a good judgment call on the type of buyer you have, the type of client you have, how do they process information, and how can they go through that process. That makes good sense. Now, another thing in the termination rights, paragraph 5C. This is a seller's right of termination. And this is for all practical purposes, the dominant right of termination for the seller. Because the buyer has a specific time frame to deliver the earnest money to the title company. And you see that language in that process as you go through the thing for under paragraph 5A2, if the last day lands on a weekend holiday, they go to the next day that's not a weekend or legal holiday. That's for delivery of the option fee and the earnest money. And specifically, we're talking about the earnest money. If the buyer does not deliver the earnest money in the timeline required, it gives the seller a right of termination. And you gotta give them that full 3 days. We get the confused because okay, it's an option thing. Okay, so till 5 p.m. No, earnest money, 11:59 p.m. all day long, whole thing. Same thing with the option fee. So you give them that time frame. The 5 p.m. is only for the option period, not delivery of the option fee. So the seller has those 3 days, 3 calendar days, not business days, 3 calendar days. And the third day, It's not on a weekend or legal holiday, the third day, counting calendar days. That's when the buyer has to have that earnest money to the title company. If they don't want to do it, say it's the fourth day. Let's say the fourth day is on a Wednesday and everything is, no worry about the language or weekends and legal holidays, so it's on Wednesday. If that's the fourth day, the seller can terminate, but he doesn't have to. Maybe that the buyer had I didn't have that much money in my checking account, we didn't transfer funds. And, so I'm gonna do that. That's why I didn't get it to the title company in 3 days. I really need a couple more days to work through the process. So I'm saying, okay, yeah, I understand that. I've been through that. We all understand how that works. So the seller can continue to work with the buyer and give the buyer more time. And at some point in time, the seller says, I think this guy's tap dancing on me. I don't think I can ever do it. So the seller says, I'm going to go ahead and terminate the contract. He has to terminate it before the buyer finally delivers the earnest money. So it's on the 6th or 7th day in the afternoon, and the seller's going to send it over to the buyer with that, to the title company. And the buyer that morning put the earnest money in the title company. Seller no longer has that right. Because before he could terminate buyer money in the title company. So, but that's an important seller right of termination. But it's important for him to understand, if the seller's sitting there with, good offers, lots of interest, maybe even a backup contract. Seller, 12 midnight on that day, he may send over and terminate the contract right away. He'll wait it off because he wants to move to the backup contract, which he likes better than this first one anyway. But seller has that option, go through that process. Everybody good with that? Now, paragraph 6B. Page 2 of the contract. Paragraph 6B deals with the title commitment and exception documents. And there are timelines in there. This is something that very, very few people even know is there. Because it's on page 2 of the contract. On the first page of the handout. That's one of the, so, yeah, okay, good, okay. Remember, who is responsible under the terms of the contract for delivering the title commitment? No.
Seller?
Seller. Look at what the contract says. Within 20 days after title company receives a copy of this contract, seller shall furnish the buyer. Seller. Now, further in this paragraph, the seller gives authority to the title company to do it. But if it doesn't get done, it's the seller who's got a problem. Now, look at the very bottom of this page, where it says, if the commitment and exception documents are not delivered within the time required, buyer may terminate this contract and the earnest may be refunded to the buyer. We actually had this happen. One of our sharpest, in fact, it was Scott and Barbara Scriver. They had a situation and the contract was with one of the major title companies. And their buyer situation had changed and the buyer needs to terminate the contract and everything else was gone. No option, no HO, all that stuff was passed. And they realized that they had not received the title company. And so they called the title company, one of the major title companies, good title company, use them all the time. The title company said, we checked everything and you're right. We don't know how it fell through the crack, but we didn't deliver it to you. They had not delivered it. Which means the buyer had a right to terminate, which they did. That's the only time I've actually seen that happen. Because most of the time, even the other title company, the smaller, that's huge. They've got to get the title commitment out there, see how important that is. So the only time this really ever comes into play is if the title company doesn't deliver the title commitment and exception documents. That gives buyer right of termination. It's important for you to know that just in case, like in Scott Barber's case, you got a buyer and everything else is passed and they need to get out of the deal. And then you check and see, because some of the attorney offices are not real diligent about getting that title commitment out in time. Your buyer may well have that right of termination. Bob,
second half-
wait, Jenna,
Oh, sorry,
Joe.
the second half of that paragraph says, if the commitment and exception documents are not delivered to the buyer within specified time for delivery will be automatically extended up to 15.
yeah, you've actually got two time frames here. You got the initial 20 days, you got an additional 15 days. We automatically extend it. When you look at this language and understand what we got here and work through it. If mid-second notes are not delivered, it's about the time of delivery, automatic send up 15 days or 3 days before closing. So you don't get to extend the closing date for the 15 days. Because you got your original 20 days.
Right?
So effectively, if you've got a contract that's fairly tight and you've got a closing date, that's 23 days after effective date of contract, you got the 20 days and that's it. You don't have an additional 15 days, you gotta have a 3 days before closing, you don't get to extend the closing date for that timeline.
If it automatically extends, how can the buyer terminate?
Because automatically extend 15 days or 3 days before the closing date. So depending on the time frame
Say you
there,
have a 6-week closing,
okay?
so now you've got
Then
20 days.
okay, so you've got to give them that extra 15 days if it doesn't interfere with the closing date. But when it gets up to that time frame, where you've gone through the 20 days, you've gone through the 15 days, you still don't have a title commitment, and the buyer can terminate. You see that? You've done your original 20 days.
Yeah, I just don't
You're
understand
down.
when it automatically renews. Why doesn't this just say 35 days?
Because it's not automatic 35 days, because you have the closing date in there, or before closing. So you gotta do this, you gotta do this 3 days before closing, so you don't get to extend the closing for this 15 days.
Okay.
Like, semi-said.
It depends on the closing.
Yeah, the closing date, yeah, because you may, if you've got a closing date 45 days down the line, then you get your 20, you get your 15. And then as long as you do before 3 days prior to closing, then the buyer can terminate.
So if my,
Wait, Joe had one, Joe.
Mine was just a comment that some title companies will send it to the agent instead of to the buyer and then CC the agent, expecting.
Send it to the agent and not the client. Okay,
It's 'cause of-
yeah, here's the rule. Here's the rule. Here's where imputed notice applies. When the agent has it, so does your client. Whether you give it to them or not, you have it, so does your client. If your client has it, it does not impute forward to you. Your client can have notice, have something, and it doesn't mean you have it. So that imputed notice only flows one way, the agent to client.
if my closing is 28th, if they get it in today, yesterday, so it's not even 3 days. I mean, so they can, I'm just
So you tell me
saying,
you don't have the title commitment yet?
we got it, but not within within 3 days.
It's not a 3 day, it's 3 days
But they-
before closing.
Yeah.
Okay,
2 days before closing.
3.
Yeah, but it has to
But I
be
mean-
3 days, right?
Do what?
We have to be 3 days before closing?
Well, you have to receive it. I mean, the time frame 20 days plus 15 days, except you don't get to extend the closing date for those 15 days. So when was your contract effective? What was the effective date?
13th,
On the what?
13th. And the
Okay, so
closing,
from the 13th, you go to what? The 33rd? Because you're trying to close on the 28th,
28th, yeah.
okay? So what you've got is that original 20 days, which is going to take you past that, in this particular section, with your 20 days that you have there. You've got to make sure the title company can get it done within that timeline and get it done in that 20 days. So with that, you don't even go into the extra automatic extension for 15. You have that original 20 days. And if the buyer doesn't get it within those 20 days, then the buyer has some termination rights.
Yes, the okay.
Should have, yeah.
I'm not going to do that, just
Yeah.
a question.
Hopefully it's going to close. Everything's looking good.
Everything is okay.
If I would have read it, it says up to 15 days, but I
Yeah,
didn't
yeah.
read every little letter.
Oh, okay.
My bad.
But that's a fairly unique right of termination. If you were talking to 100 agents, only one of them would know about it. Yes, sir.
So what I'm understanding, you got the 20 days, we have up to 15 days for a total of 35 days. If the closing is 38 days or 39, say say it's, your 35 days have expired
Yeah,
and you still don't have a title,
yeah.
then the buyer can
Buyer has rights of termination.
rights of termination. But if it's, it's a very small window that the buyer can terminate their
Depends
rights.
on how tight the closing is. Yeah,
But if the closing's within those 35 days, the buyer does not, it will never have right.
well, yeah, they'll have to terminate within that time frame. If the key is if the buyer gets it before the closing, and he gets it, if he's got his timeline, if it's 35 days have passed and he still doesn't have it, buyer's gonna have to make a decision. If you got a closing 4 or 5 days later, he's gonna have to make a decision for that third day before closing. So they've got a tight timeline, which means you're gonna have to be aware of the timelines in the delivery of the title commitment in 6B. So as you look at your client, which means you're gonna have to be in constant conversation with your client if their situations change and they're now beginning to look at ways to get out of the deal. You need to help them be able to protect the earnest money. Make good sense. But the key on this is understanding something that's in the contract that both parties have agreed to. And what the seller does is when this contract goes to the title company, the seller didn't even think about paragraph 6B. It's an automatic. Well, the title company is going to do it. Seller doesn't realize that they are responsible. It's the title company is going to be responsible. It's the title company is going to do it, but it's the seller who's responsible for it. And yet you're just going to lay that over to the title company to take care of the deal. So it's not a problem. You good? Uh-huh. So now, paragraph 6D, on the first page of the handout. So in paragraph 6D, which you see on page 3 of the contract, this is your objection timeline. So the buyer has a right to object. And I cannot say this too many times. When buyer objects to something, either because they have a big blank, but something they want to be able to do with the property, and number of days, always a number of days in the small blank in 60. Whether you have anything with big blank or not, doesn't matter. Always have a number of days in small blank. When the buyer has this right of objection, there is no obligation of the seller to take care of it. The seller doesn't have to make research, the seller doesn't have to check it out. The buyer is just establishing a basis with help. Well, if I can't do this, then I have a right to object. And 6D, the right of termination for the buyer is if the buyer objects and the seller cannot or will not take care of it, will not cure the objection, then within certain timelines that are set forth in this addendum and in this paragraph, the buyer has rights of termination. And notice as you look at the language here, as you go through the process, they have a right to, go through the process and terminate and under the objections, and if they do so, fine. But remember, this is only a right for the buyer. No obligation for the seller in any way, shape, or form. It also establishes a right that if you have revised title commitments or exception documents, then it gives the buyer in this paragraph the same time frame stated for objections to that. But it's just, it's a right because buyers too often say, well, if I put in here that I want to use this as a rent property, that means the seller's got to make sure I can use it as rent property. No. Ollie?
I was thinking when I first started, default was to put 3 days in the contract because I've come to enough of your classes and realized the importance of it because most agents don't still understand that. I started putting 7 days in my contract because nobody ever catches it and nobody ever calls me out on it or says anything. But
Why do you put 7 days?
because you have 7 days from the time you receive the commitment, the survey, and blah, 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 to make a objection for something, which just gives your client a few more days to make a decision. Is why I put the 7 days in there.
Yeah, it's okay.
Because it's not just.
Because remember, it's tied to the receipt of the information
Yes.
up to the effective date.
Exactly. And that's why I put the 7 days, because it just gives, it's just.
Yeah, you got to look at your,
Yeah.
You can look at your client circumstances, if your client's traveling or out of the country or whatever, they may need more time.
Or even just give them more time in case something comes up. To
I,
give a
I
better
need
out.
to give me more time.
Yeah,
Sometimes I'm the one that needs to review these commitments, so I want to make sure I know what's going on. So it's for my buyer, but I usually put 5 days in
Have
there
you guys
myself.
not had a counter offer where they say they want to shorten that time to 3 days?
I have not ever seen that on that.
that's never happened to me yet. It doesn't mean that it couldn't, but again,
It's happened to be twice.
most, I would say a lot of agents.
Yeah, the seller would want less days, and the buyer may want more. What you've got to do is,
Negotiation point.
well, when you put a timeline in there, make sure you thought it through, and here's why the buyer needs that much time. And if a seller count is back at 3 days, you talk to your buyer and say, okay, here's what this does to you. Here's how this shortening of the days impacts on you and your ability to do whatever research you need to do, make an objection.
Unfortunately, in my experience, a lot of the buyers on the other side, they will make issue of title company and earnest money and option fee and option time and close date. But they seem to gloss over,
Most of the time, they look at the survey issues.
yeah, or something, yeah, they'll talk about a survey issue or something like that. They, most of the time, that's just one of the things they never clue into or think about.
Yeah.
It's not that they couldn't, but that's,
Yeah.
it's just one of those things they're looking for key things, and that's not one of the key things they look at, unfortunately.
That's because the agent doesn't look at it.
That's what I mean, the agent
Yeah.
doesn't look at it.
So, Bob,
Question, yes, sir.
just like a what if in theory, you said like, can use this as a rental, could you specifically put like, can use this as an Airbnb? And then like, if.
The buyer can be as specific as they want to be, keeping in mind, anything you put in the big blank clouds the offer.
Okay,
And make all stuff, you know what, that's a weasel clause, you're just looking for a way to get out.
yeah,
So you've got to understand, now, if it's something important to the buyer, they need to know that's where they want to put it. And this is what it does for you, the buyer, is your rights of objection. But they shouldn't be sticking things in there just to be putting something.
And it's their due diligence. It's not up to the seller or the seller's agents. to
Only the
make
buyer.
the rules on rental or Airbnb in that neighborhood or for that house. And a lot of people, like you said, mistaken thinking, well, I put it in the contract, and so they're liable because they can't do an Airbnb now. It's like, no,
yeah, because I was just thinking, because I have a lot of cities that.
yes, exactly.
So,
Okay, so let's look at, go to the second page of the handout, 7B2, which deals with the seller's closure notice. From paragraph 7B, which is there on page 4 of the contract. It's confusing because it's on both sides. I'm gonna have to remember to tell them, don't put it on both sides. I said they do it say paper, but it's not good. So. Yeah. So page 4 of the contract, 7B, and 7B, remember, everything in paragraph 7 deals with property condition. Everything. Each paragraph has a heading that says, here's what we're going to talk about in this paragraph. Paragraph 7, it's all property condition. 7B is state law. It's in the Texas Property Code, section 5.008. And you know that because it says right there, pursuant to 5.008. And so you've got 3 choices in there. First choice is the buyer has the seller's closure notice at the time he's writing this offer, which means the buyer has no termination rights related to the seller's closure notice. Because he's got it, he's accepted. When you check off, in this particular situation, you check off 7B1, buyer has received the notice, no termination rights. Based on that. That doesn't mean once the seller has it, the buyer has it and takes a look at it, they said, my gosh, that is crazy. It's just, he lied about all kinds of stuff, and they may want to pursue him, but it's not under paragraph 7B. The second choice, buyer says, I don't have the notice. I don't have it, haven't received it yet. And listen, well, I put it in MLS, doesn't matter. You haven't sent it to me, I don't have it. And so the buyer has rights termination, and it's got a place for a number of days, and that's just a suggestion. It doesn't really mean anything. Because the buyer's rights of termination are tied to when they receive it. And once they receive it, they have 7 days to terminate for any reason, 7 days or closing, whichever comes first. You don't get to extend the closing date for the 7 days. Buyer just got up in the morning and said, my gosh, can you believe we thought about buying that house? You see, you live next door, people in Oklahoma. I mean, I want to live next door, people, I don't think so. Because then they just, there goes the neighborhood. So they, for any reason. But as we talked about earlier, they didn't pay for it, not an unrestricted right. It's based on receipt or non-receipt of information. But it's a very powerful right of termination. As a listing agent, you would prefer it not be 7B2. Because one of the things that you always like to have in the transaction, in fact, it's part of our compliance issue, is you want a seller's disclosure notice signed by the seller and the buyer. You have to remember, nothing in the law requires the buyer to sign a seller's disclosure notice. The buyer does not have to sign a seller's disclosure notice. And some buyers won't sign it and say, you know what? If I sign it, that tells the seller I have accepted and agreed to the seller's disclosure notice. And I think that's kind of gotten in the way of me being able to come after them later. So some buyers won't sign it if they're not required to. Now, that creates a little bit of a challenge because our compliance, we're saying we want to see a seller disclosure notice signed by the seller and buyer. Well, and actually fussed at me a lot about that. I said, well, what's in the contract? Well, 7B1, and then I don't care. Because 7B1 tells me the buyer has the notice. Now, what I don't have is a timeline. I know I got it before, on or before the effective date of the contract. Having the buyer sign it tells us this is the timeline of when the buyer received it. So if we've got 7B2 checked off, and we got the buyer signed off on it, then we know the timeline for that 7 days. Our closing. But what's really important there, it's what we got, but this creates an important right of termination for the buyer. Adam, you look like you had a question.
No, I was just gonna really make, I wanted to clarify, deliverance does not mean buyer and seller need to sign, it just means it needs to be delivered to them.
Yep. And what we tend to look at is a signature of a buyer acknowledging they've received it, but they're not required. Just like when you hand the buyer or whoever you're talking to an IABS form, they're not required to initial.
Oh, really? A lot of people don't want to sign it.
Do what?
A lot of people don't want to sign it, even if they don't want, they don't want to. sign it.
Yep. So if you give an IABS form to a prospect and they won't sign it. Well, you know what? My friend said, don't ever sign anything a realtor gives you. Take that form, turn it over. And on the back of the form, write that you presented this form to, whatever the person's name on such date. And then say, would you please initial where you acknowledge that I've given to you, you didn't sign on the front. You'll sign it. You just want some documentation that in fact you did it. And if Trek understands, you can't make them initial. But you can take every reasonable step you can to show that I did present it as you work through it. Because if the buyer files a Trek complaint against you, deal with the IRBS information, say, well, here's what I have that shows I tried. Joe, Pierce?
So is this the case, you would get the buyer on the state's option fee, put in 7B2 7 days, that would give you the same option of backing out any time within that period?
Well, not necessarily the 7 days. It's until you receive it and then 7 days after that.
Well, correct.
So if they see 7B2, a good listing agent is going to take, and if they're going to counter the offer anyway, they're going to get that over to you right away and change 7B2 to 7B1. If it stays at 7B2 and the next day after effective contract, they get it to you, then the buyer has 7 days. So that's a 7 day free option period. So you're right on that.
Same thing with HOA docs, if you can get those ahead of time and
Yeah, 3
deliver
days.
them ASAP.
But that's only 3 days.
I know, but
Yeah,
just
you're right.
deliver everything
Yeah.
on day one.
You get the HOA
The
addendum.
buyer loses some opportunities.
We're going to talk about those choices in the HOA addendum because it's very similar. Yeah.
What's that say? Well, I never received it. And you say, well.
Never received what?
The seller's disclosure. I
Yeah,
never received it. Well, I never received it.
yeah. Oh, and we get that a lot, one of the things that, we like documentation, we like emails. And it's, I would always respond to your email, Bob, and I just never got it. Could you please resend it? I had it 3 times. I mean, it's just that, there's no way, it's very hard to get past the big lie. But you say, well, and you know dang well they did. Because, you know, what are you gonna do? Drive over to their office, hand it to them, you got witnesses, affidavits, statements, you know. The old joke about a station wagon full of nuns. Oh, it's down here. There you go. You know, go through that process. Yeah, so as you work through that, now, look at 7B3. Who does that apply to?
Executors of the estate.
Well, that's one of them. But in section 5.008, there are 11 sellers. 11 categories of sellers. Now, everybody here has taken legal update 1 and legal update 2. And you talk about this. In fact, you've got the 11 sellers in the latest version. When you take it, you have it here. So there are 11 sellers who are not required to complete a seller's disclosure notice. Now, what we need to keep in mind is where we often hear several little things. One, investors say, bought us out unseen, never seen it. I don't know anything. So I'm not going to explain this. I don't know anything. Well, yeah, you do. You just like it because you do. One of the things I know, even an investor who buys it sight unseen, there's one thing he will always know about that property. What do you think it is?
The address.
What?
The address.
If it has a pool or not.
Oh.
You would never own a piece of property that has a pool and not know about it for no other reason, sheer liability. And that's one of the, in section 1 on page 1 of the seller's disclosures, that's one of the fact questions. So what they've got to do is complete it and tell us what they don't know. Being clueless about the property, never seen the property, never lived in the property, none of that gets you on the list of 11. And it is things like we talked about, trustees, court order, executor, executrix, spouse, you know, spouse to spouse, all those kinds of things. Yes, sir.
Hey, Bob, I had a situation where how the buyer made the offer. I checked obviously 7B2 because we did not have the seller disclosure. Submitted it and I emailed the agent and I said, hey, by the way, when will you have the seller disclosure notice available? And she goes, oh, I'm not supposed to do one because I'm the executor of the state. How are we supposed to know if you have a buyer? Should the listing agent that put it on the MLS or something that they're not required to do a seller disclosure?
Paragraph 1 of the contract will tell you who the seller is. And if they're an actually executor, if they're an executor, then what you'll have is the estate of paragraph 1, and then you'll have them sign as executor of the estate.
But on the Collin County CAD, the names of the owners were listed, the 3 siblings.
Well, if he's an executor, you've got an estate. If he's an executor, there was a will, and the will appointed him an executor or her an executrix. And so the seller is in fact, the estate, and he's operating as an executor of the estate. You won't have the 7 or 8 brothers and sisters as heirs. Because what you've got is a will that's been probated, and the court has said, this is the person who's executor. And so the seller would need to be the estate of, and the executor would need to sign it as executor of the estate. You won't have the 7 or 8 brothers and sisters. If you haven't taken it through probate, if you don't have, you may have a will that states all 7 or 8 brothers and sisters are going to be executors. But unless you do that, the estate is the seller.
So I said, oh, okay. The real list also still has the names of the parents, I guess. She goes, oh yeah, go to Collin County CAD, pull it up by the address, and it'll show you the names of the new owners of the new. And it was.
They show you the names of what?
Of the 3 siblings that you're supposed to put on the contract.
Okay, are the 3 siblings now the owners of the property?
Yes, yes. It is.
Okay, okay, this is an important distinction. If you're operating as an executor, you're exempt. If you have inherited the property, 3 brothers and sisters inherited and are now selling it, you're no longer exempt. You have to complete a seller disclosure notice.
Can you repeat that again? Sorry.
If you are the executor under a will, it's the only time you have an executor under a will, then you're exempt from, I think it's number 6 on the list of 11. If, however, you have inherited the property and now own it, So the will has been probated, it's gone through the process. These three brothers and sisters now own the property and they're gonna sell it. They're no longer exempt. They have to complete a sale disclosure notice. And in that particular case, if they now own it, all three names go in the contract.
And that's what I
So we're
did.
not talking about 7B3. We're talking about 7B1 or 7B2. Can't have 7B3 in that case. They're not an executor.
Again,
You're actually an heir.
again, the agent said, we don't have to do one.
Sure you
Because
do.
I mentioned.
Sure you do.
And I said, well, that's why it's check 7B2.
Yeah.
I did not know, and when I went to the Collin County CAD, it's got three names, that's the only.
Well, then they're not executors. They're owners of the property.
So obviously.
And they're no longer exempt. So sometimes, depending on how you're doing with the other agent, remember, you're gonna lay this off on your buyer to make some decisions about, particularly about sales disclosure. Buyer said, you know what, I don't care. These people live out of state, they've never seen the property, they don't know when they just inherited or whatever, I don't care. I'm gonna do inspections anyway, let's get this deal done. So your buyer gets to make a decision. If they talk to the owners of the property and they say, well, we're exempt, say, okay. Go ahead and send them the list of 11. So, okay, show me where you fall into that list. I don't see it. I don't see where, because you three are the owners of the property now. You just, when you were executors or when you were in some other role, then fine, but you're not. You own the property now. You inherited it. You own it. Now you're gonna sell it. You just went off the list.
Well,
I have to do it.
our offer was still accepted, so I'm not gonna go through all that trouble.
No, but I mean, but this is an important point. This happens a lot. This happens a lot where you have listing agents who say, well, yeah, my seller never lived in the property, so I don't have to do it. And the buyer has to make a decision whether they want to go along with that or not. What you're really gonna do, like in that particular case, all three of those siblings need to be in paragraph 1 as sellers of the contract.
And that's what I did.
Yeah, you generally don't have a room, so you may want to go to an exhibit and list out all the sellers. Same thing for the signatures on page 8. You may want to go to it where you list out who the sellers are and their signatures, because you don't want to try to scrunch stuff in. And if you've got 3 sellers, if all of them are nice, simple names like Bob Baker, then you may be okay. If you got some longer, more complicated names, you may not have room. Don't try to scrunch it in, go to a separate sheet of paper, list it out as an exhibit in paragraph 22 of the contract and go for it there.
Hey, Bob, this is Laura.
Okay, Laura, got a question? on
Yes,
the
sir.
Zoom?
Is there a downside for an executor to complete a seller
Is there a
disclosure?
downside for executor to what?
To complete a seller disclosure if they want to?
Okay, so Laura brings up a good question. Let's see if I can increase the sound here at all. Good here. Some way to increase the sound. Like that optimism, like that optimism. I was trying. The Laura's question is for downside. Here's the key. Even if you're on the list of 11, you are required to disclose what you know. So if let's say that you're the executor, your son, it's going through probate and everything, you're the executor, and you're gonna sell the property. But the last couple of years, you lived in the property with your last surviving parent. And you were involved in getting the foundation company over to get all the work done, and foundation work's been done. You have to disclose that. You have to disclose what you know. Now, you don't have to complete a sales disclosure notice, but you have to complete what you know about the property. If you know some defects, some things about the property, you have to disclose it.
Laura, can you talk again? See if you're loud enough now?
Sure. Can you hear me?
No,
No, you're not coming over our big speakers.
Uh-oh.
So like, so with that said, like if even if you're like, I guess, an investor who or what if you're under the 11, but you just have, I would think have some, knowledge of the property, and you knew it had like a roof that was put on before you owned the property. You would just have to.
of course, as an investor, you're not exempt.
Right, that's why I said,
Yeah.
in that 11, if you're in that 11 and say you.
Yeah, if you're not in the 11 and you have knowledge about the property, defects, things that a buyer should know, you have to give them that information.
Okay.
Yeah. And there's no specific way to do it. The best way to do it is go ahead and do a sales disclosure notice. And note that on there. And what you'll note on page 1 of the sales disclosure notice that you've never occupied the property. So you made that disclosure on it, but then if you have other things you want to tell them about, And make sure, we do not think, that's why you see in the institutional sellers and their addendums that they've got there, where they go ahead and disclose all the things they know about the property, even though they may be exempt from a seller's disclosure notice.
Can you try again, Laura?
Can you hear me now?
Better.
Well.
Okay, so follow-up question. I was just gonna send it in chat. Where, if they did not do a seller disclosure notice, where would they disclose the information?
Okay, they could put it on a sale disclosure notice. They generally in page 1 say they've never occupied the property. There is no form for this. There's just a requirement on the property code that if they know things, even though they're exempt from the sale disclosure notice, they're not exempt from telling people what they know.
Thank you.
Thank you. Yes,
I
ma'am.
just want to make sure I understand, it's like being an executor, let's say my brother-in-law and then his wife died, and then there are kids. Now I become the executor of the will. I
Are
don't need-
you named in the will as
Yes.
executor? Okay.
Yes, so I don't need to do a seller's disclosure.
So you don't.
correct? Okay, I
Yep.
just want to make sure.
Yep.
Okay.
Quick question,
Adam?
just to kind of follow up on that. If they are on that list of 11, they don't technically need to fill out a seller's disclosure, but they do have some knowledge and they've listed that. I mean, I guess just to protect our client the most, what should we still just check off under seller's disclosure, checkbox 3 or?
Yeah, if they're not required to, you can check off 7B3.
Okay,
But you could go ahead and provide that information to a buyer
okay.
to work with that process. Whereas you're required to tell what you know.
Gotcha.
Okay. Yeah.
Makes sense.
So a lot in the self disclosure notice issue. And the big thing is it's a big right of termination under 7B2. And that's a key thing, for buyer's right of termination. So 7E on the next page, page 5. Now, the two things in 7E. The big thing here, and well, the other one comes in just terms that cause us to terminate. Lender required repairs, usually big things, roof, foundation, stuff like that. And they come up with the repairs and the seller said, yeah, those things have to be taken care of. I'll pay for it. But if those repairs exceed 5% of the sales price, even if the seller agrees to pay for it, buyer can terminate the contract. The concept of that, you got an $800,000 house. And the repairs, lender required repairs come to $45,000. I said, whoa, I don't want to buy a house at the very beginning. I got $35,000 in repairs. I don't care if the seller's going to fix it or not. That's the only part of that deal. I can terminate. Under paragraph 70.
Only if it's lender required repairs.
Yeah, only lender required repairs. That's all we're addressing. Yeah, exactly.
So would the seller have to disclose that, and then like the buyer
Disclose what?
disclose that, the required repairs that cost?
So lender required repairs are going to come from the buyer, from the buyer's lender.
Okay,
Yeah.
But they do.
And it comes generally from an appraisal or other things from an inspection, the inspection to say the see or whatever it might be. It'll come from the buyer side. The little glitch we have here, and I don't really know any really good way to resolve it. I gave an example, 45,000 repairs. Maybe it's a little closer. Maybe it's 41,000 repairs. And those are repairs that came from the buyer's lender. And seller got a list of all those repairs and says, well, we got an estimate and those only come to 39,000. So you don't have a right to terminate if we agree to do it. We don't have anything here that tells us, here's who has to come up with the numbers. And here's whose set of numbers we have to honor. This becomes a negotiation between the buyer and the seller. So we don't really have any control over it. But it's an important thing to know. If your buyer says, whoa, that's a lot of repairs there. Then the buyer said, well, I don't own out that he can do that. Now, 7F, on that same page. If the buyer, if the seller doesn't do the agreed, yes, question?
No.
Okay, doesn't do the, she's trying to get on Zoom.
Yeah, I was just right in the middle of the camera, I realized that.
Yeah, people were saying, is that Tommy? Yeah, that's Tommy. You can recognize
I'm
everybody.
looking at my lunch here. 2 orders to go.
So if the seller fails to do the agreed upon repairs, and that's a 7F where you deal with that, the buyer can extend the closing date up 5 days if necessary to give them more time, which parties can mutually do that anyway. But the buyer also, if seller to do what he's agreed to do, buyer go to paragraph 15, the default paragraph, and one of the remedies in the default paragraph is a right to terminate. So if seller doesn't do what he's agreed to do, he say, oh yeah, I'll do these repairs, and agree to it, amend the contract, and then he doesn't do it. I said, well, I'm gonna terminate the contract. He said, I'm gonna go to paragraph 15, default paragraph, I'll terminate. So that's a right of termination. The seller doesn't do what he's agreed to do in the way of repairs. And that's reasonable. Everybody good with that? On the same page, paragraph 9A. Our closing paragraph. There's some good language here. In paragraph 9A. Your last sentence, if either party fails to close the sale by the closing date, the non-defaulting party may exercise the remedies contained in paragraph 15. So if either party decides just, I'm not going to come to closing, I'm not going to do it, buyer or seller, either one. Let's say the buyer is just not going to close and you've got a seller. You're going to have your seller go ahead and close. So that they're now performing. And the buyer is clearly a defaulting party and the seller is a non-defaulting. So the seller can go to paragraph 15 and go after the buyer. And then the reverse is true. If a seller fails to close, the buyer says, well, I'm going to go ahead and go to the title company. I'm going to close, do whatever I need to do. And then I'm the non-defaulting party and I'll go after the defaulting party. That process. So it's everything in paragraph, one of the remedies in paragraph 15, the default paragraph is the right to termination. It's one for it. The buyer if they're non-defaulting or the seller if they're non-defaulting. Go through that. Everybody good with 9A? Go to the next page. It's actually on page 6 and 7. We have paragraph 14, the casualty loss. That's gonna really screw you up because you got to flip over to the side of that page. Now, casualty loss, some damage to the property after there's a contract. There doesn't have to be any insurance involved, but there typically will be. And that's one of the options we'll see that the buyer has. But property is damaged, and of course, in our area, particularly this time of year, we have a lot of that things going on. We have a bunch of that recently. The seller is obligated, and the seller needs to know this. He's obligated under the terms of this paragraph to restore the property to its previous condition as soon as possible, certainly by the closing date. Now, sometimes through no fault of the seller, because all the adjusters are busy and whoever's busy, all can't, they just can't do it. Well, you know, I'm happy to, I want to cooperate, I'm going to work this thing, I want to get this thing closed. And if we can't, then the buyer can extend the closing up to 15 days to give him time to do it. And that may be enough. Remember, the two parties can mutually agree to extend it as long as they want to. So, buyer says, I still won't have. But a few years ago, we had all those tornadoes over in the Rowlett area. One of our Rockwall agents had a buyer on a property that was literally destroyed by a tornado. And it was, there's no way you can totally redo the property and all that kind of stuff. And the buyer said, I bought that property. It's a specific location. It's a specific view of the lake. I mean, it's exactly what I want. I still want the property. And so he worked through the process and he went ahead and made the purchase and he worked with the seller's insurance company, get proceeds and work with it. So they can still move forward and do things as he worked through it. These are options. Or the buyer just say, I'm going to terminate the contract and reverse money back and well. So this is an important right of termination as you work through it, because even when you've got sellers who are willing to cooperate, it just may not be possible given the amount of damage and supplies and materials and all those kind of things. But at least we've got the process in paragraph 14, there, page 6 and 7 to work with. And particularly in our area, this time of year, we had the thing, just last month, all the houses up in Allen. We're working through it, and so, you know, you have to be, both sides need to understand, here's what we agreed to. And especially the seller says, you know, you got to do, and if you got sales, say, I'm not gonna do anything. Then the buyer says, well, you really should, you really agreed to do this. Buyer says, you know, I'm gonna go through the process. And if the seller fails to do it, buyer can terminate the contract, earns money. And then, or accept property damage condition to assignments and work process. It's one of those things that it gives them a clear process that we can work through and deal with. Have you all had any of this? Have you had enough of in our area? Because, you know, where you have to deal with that. And it all comes down to how cooperative the parties are. It's one of those times that when we decide to move forward and amend the contract and deal with that, the language for the buyer, what the seller's agreeing to do is really important. Don't just say, well, seller file claim and whatever the insurance company's gonna do, they're gonna do. You gotta be really clear and specific what the buyer wants to have happen. Tommy?
So the buyer, a hailstorm, okay, you've got a busted roof. Buyer has to write some sort of, I've gone through this, but it's been a while. Buyer has to write the seller and say, we want a like-kind roof, 30, just prestige, blah, blah, blah. Or the seller just automatically knows he has to do it as compensation.
Yeah, it's important to do that, take the next step, because all the contract says the seller will restore it to its previous condition. Whatever the material was, whatever, like in the case of a roof, whatever was there before, is what we're presuming is going to be doing. But it'd be very valuable for the buyer to have an amendment that's very clear and specific. Because roofers' warranties are tied to the fact that the roofer and the material is approved by the major manufacturers. That's how they end up with a warranty. And a roofer is not accepted and approved by the major material manufacturers can't give up a valid warranty. So we need to make sure a buyer says, yeah, I want to make sure this is what's done and this is how it's done. Otherwise, Tommy, in your particular case, you know, the buyer is just accepting, hoping that the seller agrees with, and the buyer both agree with, here's what it was before, and here's what we'll look at now. Theoretically, the buyer could change the color dramatically and things like that. However it was at the time you decided to buy it. Yes, ma'am.
I had one last month, seller, and they had to get a new roof, and it had to do with age, not because of house form. And it was written in there, and then we couldn't get the color that the buyer wanted, the exact color, you know, it's like if you go to a paint store, they all look alike, they all have 20 different names, and it was quite a contentious thing to get them to agree on the new color, even though you couldn't really tell them side by side the edge of the names. It was a little bit of a. It wasn't like it was a brown shingle and they'd ask for a gray or something. It was just.
That's why you use phrases like satisfactory to the buyer. Yeah, the risk to the seller is exactly what you're dealing with. You know, how reasonable, unreasonable is the buyer going to be? Once you're a third shade of teal green or whatever it might be, says, you know, we got to finally make some decision here. Well, now you deal with negotiation between the parties. Tommy?
I say we have a lease back. Sellers in the house will get a hailstorm. There's a paragraph in the lease back that says that the seller's responsible for any all damages and repairs, but that's on the new.
Paragraph 14, paragraph 9 deals with casualty law. Paragraph 9 of that lease is a casualty loss and wear and tear. So you're right in paragraph 14 of the temporary lease. The seller or the tenant is responsible for things that break and all that kind of stuff. But paragraph 9 deals with casualty loss. And here's your challenge with paragraph with casualty loss. Comes down to an insurance issue. That's why we in two places say to buyer and seller, make sure you talk to your insurance agent. Because past closing, seller no longer has a homeowner's policy because he doesn't own the property. And the buyer has a homeowner's policy with the tenant in the property. He needs to make sure he's got coverage to deal with not only the property itself, but any personal items. We would expect the seller who's a tenant in the property to have renter's insurance. Somebody had to protect his personals. And then the buyer to have something to protect the property. You gotta make sure they talk to their agent and find out what their agent says, yeah, here's what you got. Whatever coverage you got.
Discover this during the option period.
Say, do what?
What if you discover, like theirs is supposed to do an amendment, because they've already signed it.
Yeah,
So what if you just, in the option period, you come out and discover that there's hail damage?
yeah.
There's a lot, and so it wasn't disclosed, seller's disclosure to your.
Maybe it hadn't happened yet.
Right, and it's there's, how do you do it, you know, once?
Yeah, of course, your advantage here is because you're
Do submitting an offer, not.
not in the contract, so you're submitting an offer.
Submitting offer, and that turns out it's hail.
So when you're submitting an offer, you're gonna go through a negotiation between the buyer and the seller of what you know now, and here's what we require. That's why when we talk in the classes about really specific language, what you would do in that point is you would almost certainly try to treat it as business details. You would have an addendum that addresses repairs, and you put that as in paragraph 22 of all your exhibits. And then when the buyer would write in, they could put it, when we look at our as is paragraph,
Yeah.
can you put in there where the seller has to replace the roof or whatever and be very clear and specific? So 72 would be a good place to
I
put
do
that.
too, like, since
Yeah.
the property has it, it's a nice place.
Yeah.
Whatever.
Yeah, that'd be a good place to do that. Sure, yeah. Good idea.
In,
Question?
yes, back. In that vein, back on, 6D. No, that's secondary use.
Pardon?
I was saying on 6D, you couldn't put in there must be insurable.
What you would more likely do is put that in paragraph 11, but you could put that in 6. Here's your challenge, and insurability is an important part because insurability is a property approval factor. When you talk about insurability, what does that mean? Insurable at, the buyer says, well, I want to make sure it's insurable by a company of my choice at standard rates. Because virtually every property is insurable at some level, at some premium, but in a high risk property or whatever, high risk premium, you get insurability. So just, well, I've got an insurance company that'll insure it. In fact, I've got insurance on it right now. Use them. I said, well, I want my own company and I want a standard rates. I'll work through that. So if you're going to do insurability, that's an issue. You want to make sure you have good language where the buyer is very comfortable. Here's what's going to happen. Because insurability is a really important issue for condominiums. And it's not usually a property issue. It's an insurability standard with reserves and other things that they've got in there to be FHA and VA qualified. Good on that? Okay. So we just did paragraph 14. We talked earlier about paragraph 15. That just gives the non-defaulting party some options there, and 3 options. One, buy or terminate, gets their money back. Second, buyer can, in fact, other relief allowed by law, which is viewed as damages, which is as a general rule, a hard suit to work. And the third is buyer take care of somebody to liquidate damages and work through the process. Persons they can sue for a specific performance, damages, and then take care of somebody's liquidate damages, which means that's all they do. They don't do anything else. They give money back and we'll move on. Kind of thing. Or so says, give me that $5,000 and we're done. Because that ends all remedies. If the buyer is going to sue for, or seller is going to sue for damages, then they're almost certainly going to include the amount of the earnest money. And it must be whatever total number they come up with. And their plaintiff attorney is going to help them do this. Now, termination rights and addenda to the contract. So you've got the third party financing addendum there. Don't let me ever let them do 2 sides. I've got one side where I can imagine how very challenging it is. Third party financing. We've got 2 paragraphs that are important. Paragraph 2A, our approval. Paragraph 2B, property approval. Even in today's day and age, we still occasionally have to explain to a lender. Not looking for final loan approval. We're just looking for you to approve the buyer. Buyer approval as defined in paragraph 2A. And when you look on the second page of third party financing, done by approval. Has been obtained when the terms of the loans described above are available. So in paragraph 1, conventional loan, you put the interest rate and so forth. That those are available and lender determines buyer has satisfied all lenders requirements related to buyer's assets, income and credit history. Nothing to do with the property being bought. No appraisal issues, no insurability issues, no underwriting issues, no title issues, nothing else, only the buyer. If a buyer within that number of days determines they cannot obtain financing. And there's not anything that really says, well, you gotta get something from your lender, send it to the seller saying, hey, here's why it can be approved. It's not required. Like that language is in to be property approval, it's not in buyer approval. So if the buyer terminates during that time frame, all he has to do, and that's when you look at your notice termination contract, that particular form. So it's the last 2 pages of your little package here. One of the choices that you have there are the buyer's notice of buyer's termination contract. Is the second choice, buyer cannot obtain buyer approval in accordance with the third party financing of the contract. Buyer checks that box, signs it, and that allows him to terminate the contract. So you receive that on the notice of buyer termination contract should be like the last page. The last page. So that's a right of termination for the buyer. Your buyer needs to expect, depending on the circumstances, flag from the seller. Flag from the listing agent. Whoa. You convinced us how good your buyer is. Now what you lied to us, which I talked about that earlier. And you're going to get from listing agent seller. Well, we need something from your lender. It doesn't say that. It maybe implies it, maybe in person in some way, shape, or form. It doesn't really say that. So be prepared for some flags here. Now, if the buyer really wants to terminate, if the seller's sitting there with a backup contract better than this one, fine, you move on. Terminate it, get your money back and move on. That is a right of termination, is for a very specific number of days. Now, the second one is the property approval. And the property approval, where the buyer gets to terminate because their lender doesn't approve the property. And there is a timeline for conventional loans. If the buyer is going to do that, he needs to do it no later than 3 days before the closing date. And he's got to have something in writing from their lender who says, this is why we don't approve the property. He's got to do both of those in order to terminate under property approval. Now, if it's FHA or VA, still has those same requirements, except it goes all the way to closing. You don't have a 3-day time frame. Yes, sir.
What would be, for instance, on that lender approval, not approving a house? Condition,
Well, lender required repairs
okay,
be one of them. Insurability, title issues. If you didn't use the appraisal addendum, it'd be an appraisal. Maybe it's if it's an FHA or VA loan, you couldn't use the appraisal addendum. So those would be the most common things we see are appraisal. We occasionally will have where, we looked earlier at 7E, with lender required repairs. If they can't come to some agreement, we see this on the handout further down, contract terminates. In this case, property approval, they didn't have lender required repairs, but they couldn't agree on repairs issue. And maybe the appraiser for the lender made an appraisal subject to, here's how we'll appraise it if these things are done. And those things didn't get done. Lender said no. Usually it's going to be an appraisal issue or a title issue. Could be we have one that was an insurability issue that dealt with the roof, and the seller refused to file a claim through the process, and buyer says, lender said, I'm not going to insure this. Because if we're to insure it, we're going to take an exception to the roof. We're not going to insure your roof. What kind of insurance is that? It's roofless as opposed to roofless.
You're funny.
Yeah, that's real pretty. I guess but property approval is an important thing, and we need to make sure we understand that is a right of termination to buyer has. We give that now. The next page of the handout Back of that. Metro HOA didn't. Now, we have, I think we've made some good inroads. Thank you for being here.
Thank you.
Thank you.
Sorry, I got 3 o'clock.
Well, good luck with it.
Other points taken off if you leave early.
I should be out right, close the deal.
Real late, there are.
Close the deal. Yeah. So, here's the key here. We have tended to focus on A1, but we've made progress in the marketplace where we're looking at A2 and A3, especially A3. Because that's a good situation where if the listing agent has done their job, talked to sellers, so yeah, let's go and get this stuff done right now. We're going to have a lot of interest in the property, and I want to get rid of this right of termination for the buyer. So let's go ahead and get this done.
Mandatory membership in property.
Yeah. Yeah. So, that's when A3 becomes a really good choice. A1 creates that same right of termination that we saw in the seller disclosure notice, except it's 3 days. You know, you got a timeline in there, the number of days. And then once the seller gets this to the buyer, he's got 3 days to terminate for any reason, just like on the seller, for any reason. So that's a powerful right of termination. A2 is a strange choice. I've never seen A2 used. And I've never had a really good explanation from anybody on the broker lawyer committee who said, well, here's kind of what A2 is a choice that wasn't there when I was on the committee. It was added later. And it's a strange situation. The buyer obtains the subdivision information. And back when the law hadn't changed yet, where HOAs didn't have to provide it to a buyer. In fact, they required a contract, and even now you have HOA problems with when a buyer requests or a buyer's agent requests that, well, I don't know. HOA says, here's the only people we want to hear from. The title company. Have them send a request and we'll move forward. And somebody has to pay something to work it. But buyer obtains it in A1 and A2. And gets the information. And when he gets that information, he can terminate within 3 days after receiving it. So buyer has to do it at buyer's expense, buyer obtains it, buyer pays for it, and you got rights to termination. Now, it creates a situation at the end of this paragraph that if they're unable to obtain it, the subdivision information, and they just can't get it within the time required, then buyer may, this is good language, as their sole remedy. The only thing they can do is terminate the contract and carry money back. Now, most commonly, what causes this to happen, and it does happen, not because this choice is made, I've never seen it, but we do this, is the HOA, particularly the smaller HOAs, can't get this stuff done in the timeline in paragraph 18. You just can't get it done. So buyer says, well, I'm not going to wait forever. You get it to me, I'm going to terminate and move on. So that's it. Now, I like A3 a lot. I like A3 a lot better than A1 for both sides. But in A3, all you're doing, the buyer already has the information. And all we're dealing with is a choice of the updated resale certificate or not. And buyer says, yeah, I want one. Then he's got termination rights when he receives the updated resale certificate. But otherwise, he says, yeah, he says, I don't need one. I'm good with what I've got now, and then we move on. A3 takes away that automatic right of termination that you see in A1. So I like it. It's a really good choice, but it does create a right of termination.
Inevitably, the lenders and the title companies say they have to have a resale.
Yeah, and see, paragraph D of this addendum addresses that.
Yeah.
If the buyer says, I don't need one, and the title company says, well, we do. And then they got 2 boxes, and paragraph D says, who's going to pay for it? Buyer or seller. So if you're not going to get an updated resale certificate, the title company or lender said, well, we need one. Then you have to decide who's going to pay for it. And by the way, remember an updated resale certificate? How much? No.
No, it's.
Caps at $75.
Yeah.
$75 for an updated resale certificate. In fact, some of them won't charge. But it cannot be more than $75 for an updated resale certificate. That's maximum. Yes, sir.
Do you think that HOAs have too much power?
Oh, way too much. Way too much.
Is everything that
Yeah, here's what's going to happen. It's been worked on. Every legislative session has been worked on. And What's not gonna happen is they're not gonna totally lose lien rights. Because you're sitting here in a nice big gated community subdivision. And if you don't have the ability in some way, shape or form to enforce dues, who's gonna pay for all the common area? What they'll still, they'll lose their ability to foreclose on a homestead because they didn't pay their dues. They'll still have lien rights, and what they'll do is what the taxing jurisdictions do. We got a lien right here. Eventually, this property will get sold. Somebody will die, somebody will sell it, then we get our money. And know that they'll eventually get the money. They're just not good to come after them foreclosure. That's gonna happen. Every legislative session, we move it a little bit closer to doing that. Because they so abuse their power. It's just ridiculous.
I got a tribute. I sold a house out there recently and the seller had to pay 1/2 of 1% of the sales price as a convenience fee. On
Yeah.
an $800,000 home.
It's his own fault because there were the rules in the HOA that he bought a house in. And he allowed it.
Okay.
I mean, and that's the problem. They say, well, you know, and that's what we require and we require that. And if you don't like that, then don't buy in our subdivision. Pierce?
Do you think they'll have the right to limit a percentage of homes to be rented?
They already do.
I already have that.
Okay.
That's already there.
Yeah, there's caps.
Is there like a certain percentage or?
Depends on the HOA. Some of them say 30%, 35%, different rule. Here's the problem with that. It changes. It changes. You've got a contract and during the term of that contract, it changes. And theoretically, when that change is made, the seller is supposed to get that notice, the seller is supposed to tell it to, notice here. When you look at that, big bold print, as you work through go through the process, it's very bottom. Yeah, material change. If a seller becomes aware of any material change, subdivision information, seller should promptly give notice to buyer, buyer may terminate contract prior to closing by giving written notice to seller. If any of the subdivision information provided was not true, any material adverse change in subdivision information. So any material adverse change can be anything. Literally, if I didn't like the font, didn't like the color of the paper, anything. So it gives, when that change is made, the buyer bought it to use as a rent property. And yet all of a sudden, because of the change, they just dropped from 35% to 30% and no longer qualifies, that he can terminate the contract. Hopefully you get that information beforehand. Sometimes you don't get that information beforehand and they go and close and then they find out. And that's a little bit of a challenge.
I had situation,
Do what?
situation that, in the MLS, whatever the name of HOA, it was wrong. So what happened, the title company approached them and then at the end, they're supposed to get it on by Friday. Friday, the HOA canceled after 10 days.
Cancel
Then
what?
we are not,
Cancel what?
didn't send anything, so we are not the HOA of this subdivision. And then they have title company have to do that again, so it was
There's always some things that happen with wrong information.
it happens, so.
It happens. I mean, that's just the world.
Okay.
That's just the nature of the beast. Yeah,
So
and you have,
it
and the title company said, well, we got to have the correct ones, and we may cut it. So that we know where we're getting the information, so the buyer can make a decision what to do it. Yeah, that happens, absolutely. So is everybody good with the HOA addendum? Now, appraisal addendum should be your next box there, or your next page there. Buyer's rights determination really are in choice 2 and 3. And 2, because you've got a dollar amount in there. So if the dollar amount, if the gap is excessive, or so the buyer may have a dollar amount here that's going to really say, well, I'll cover up to 10,000. If more than that, buyer terminate. Number 3 is an additional right to terminate. It's not a waiver. 2 is a waiver, partial waiver. Number 3, buyer says, I don't care what the lender wants to do, I get to terminate. And he's got a dollar amount he puts in there, and he has to provide to the seller a copy of the appraisal. Where this comes into play is when the buyer is doing a really large down payment. Let's say put 50% down, $400,000 house, put 200,000 down, going to borrow 200,000. And the property appraises for $390,000. Well, the lender's looking at the appraisal of $390,000 and a loan of $200,000. I'll make that loan all day long. And I said, whoa, no, I don't want to buy a house for 40,000 that's appraised for 390. I want to terminate the contract. Well, and the lender said, no, we're gonna make the loan. I said, no, you're not. Paragraph 3, I have the right to terminate the contract. It didn't appraise for 90 puts in here, the sales price, which what you get to put in there is a sales price. So I said, yeah, we're gonna terminate. That process. So it gives the buyer that additional right to terminate. It almost always applies in the case of a large down payment for a buyer, which frankly could be as low as 20,000, 20%. This gives that buyer additional right of termination. That's a valuable one.
You would never check 2 of these boxes on here.
You can check 2 and 3. Yeah, you could check 3 with any of the other boxes because 3 is an additional right. 1 and 2 are waivers. You could check, you could see 2 and 3 check both. Yeah, you can do that. So everybody has good with that particular situation. The appraisal didn't. And remember, all we're dealing with there is the appraisal. I deal with any other buyer approval issues. It's the appraisal.
Wouldn't make sense though to do with number 1.
No, because, well, you could, yeah. See, 3 is additional. 3 is not a waiver, it's just an additional right of termination. So you could, because remember, in 1, you're giving up the right of appraisal issue. In 3, you're saying what the 3 really does is puts the buyer in control over what his lender wants to do. That's what's really happening with 3. So it's not gives him a right of termination. I've never seen 1 and 3 both done. I have to really think through how a seller would view that. Well, we kind of waived the appraisal issue, but oops, now they kind of have it again back in 3. So you're kind of giving it up and taking it back.
I'm putting a limit on 3, right?
Yeah, you are. It's going to be always going to be the sales price. 3 is always going to be the sales price. I said, if it doesn't appraise for the sales price, I get to terminate the contract. Period. I don't care what the lender's going to do, I get to terminate. So it's been an interesting situation to find both.
And that's only like when you find that mostly when they're putting large amounts
Very
down.
large down.
So that the loan amount would be less than the sales price anyway, but.
Yeah,
But it might not appraise for the sale price.
yeah.
It's a protection kind of.
It is a protection, yeah. It keeps the buyer in control. You're exactly right. Keeps them in control over their lender. Residential lease addendum regarding residential leases. Paragraph B1, B1B. The buyer has not received the leases. He now gets them and he has a right to terminate. In B4,
Well, where are we at?
on the residential leases.
The addendum.
Addendum regarding residential lease.
What's it on the flip side?
There we go.
You got it? Okay. And then on that same addendum, B4. Because in paragraph B3, the seller makes a statement about all these things. That says, yeah, accept as described. These are all true. And if they're not, here he puts it. And if it changes, if those changes and buyers and the seller's not able to correct these things, he says, well, that's not true anymore. Then the buyer has a right to terminate his contract. And the fixture lease addendum, which is on the backside or the next page, whichever one. Backside.
Yeah.
Of the residential lease. This deals with in B2. He's not received the leases. When he gets them, he can then terminate 7 days after receiving.
So would it behoove the listing agent to upload all those
Oh,
leases?
absolutely, absolutely. Otherwise, you're giving up rights. Otherwise,
I've been doing this for a while.
otherwise you're giving up rights of termination to the buyer. Yeah, absolutely. You're exactly right. Under the terms of the contract, back in the contract itself, we talked earlier about 7E, lender required repairs. This is one of those things, if the parties can't come to some agreement on who's going to pay for lender required repairs, contract terminates. And that's the terms of a contract that doesn't give somebody a right of termination, Although the party said, well, I'm just not gonna do your repairs, that's kind of a right of termination, but what it does is it causes the contract to terminate. Now, for the addendums, as you work through this, sale of the property by buyer addendum, which you have there, should be the next page. Go back, sale of addendum for sale of the property by buyer. In paragraph A, this is again one of those terms that if in paragraph A, this date here, when this date hits, if the contingency is not waived or satisfied, the contract automatically terminates. Only place in the contract or an addendum contract where you see the word automatic. Some title companies, if this happens, will release insurance money with just the buyer. So you know what? It either is or it's not. So you're either pregnant or you're not. I don't care. You know, if you're not, here's the marriage money. So it's an automatic. So that's an automatic right of termination. Now, what can happen is if the parties want to continue this thing moving forward, because what happens as you work through it is we change the date, because we put a date here, usually maybe the closing date, and that gets changed. Well, the parties can do an amendment, item number 9 on the amendment, and change the date here, in paragraph 8. Keep it going. Or the buyer can say, well, okay, I'm going to take my chance. I'm going to waive the contingency. So the contingency will go away, so we get to continue to move forward with you. But the buyer has lost that important contingency that he's going to sell his other property. So, yeah, I feel pretty good about it. It's a cash deal. It's going to close any minute now. And of course, we know what's the case. We see that right of termination. Now, if you're dealing for a backup contract, same thing. This is how this is different than a seller of the property is there's no right to waive. You either are or you're not. If you are backup and the first contract is still in place, has not terminated, when this date hits, your backup terminates. Period. It's gone. So the first contract is there. Now, if the parties can mutually agree to change this date, they say, well, we want to keep this backup going. But it may be the seller may say, you know, I didn't like that backup all that much anyway. It's kind of tricky. I feel good about my person. So the buyer said, I'm not going to agree to change the date, just contract term. What happens more often is parties don't agree. I mean, don't understand that this is about to terminate, and they think you've got a backup alive and moving well. And then the first one goes away. You're ready to go to the backup. Somebody reads the backup addendum. The buyer said, I didn't realize that I really didn't want to stay in that backup. But guess what? They're not in the backup. Because if the first one terminated and everybody wanted to go to the backup, but the backup contract had passed that date, that contract had terminated. It was gone. And that may not be what the parties wanted to do. So that becomes that becomes an important little deal there as you work through it. That makes semi-sense. Now, the last thing I want to talk about is we're all been good, which is about it, is reading through the notice of buyer's termination contract form and the seller's notice termination contract. On the buyers, here's where we get into trouble. You've got 7 pre-printed items and you've got number 8. If your buyer is going to terminate under one of these provisions, please check the correct one. If your buyer hasn't paid the option fee, you don't get to check number 1. Because he doesn't have that right of termination under number 1 because he hasn't paid it. And make sure you see that we make a distinction between buyer approval, property subject to mandatory membership, right to terminate under B2 in the seller disclosure notice, going through the process of the lender's appraisal, and then dealing with the residential service contract, either 6D the contract or 6C the resident service contract. To make sure you understand each one of those when your buyer says, well, I've got a right to terminate under this provision, and make sure you check the right box. We sometimes see number 8 check, and we see language like buyers still want to buy the house. It's not a basis for termination. And notice that the only people who sign this are the buyers. Buyers want to sign it. We don't need anything here from the seller. And now it also has important language that this is not an election of remedies. Release the earnest money is governed by the contract. This only terminates the contract. This doesn't resolve the earnest money issue. Right, give that? And then the notice of the seller's termination contract, the only really pre-printed text that have deals with what we talked about earlier and earnest money. I don't recall any, I don't have any good examples of other sellers' rights of termination. But that's the most dominant one that you have as you work through it. Has been helpful information, hopefully. You good? Very good. Thank you guys to be here.
I don't want to pay to say consultant or attorney. I wouldn't be able to pay an attorney already.
Well. I know. Well, and the reason we have still an attorney is because the attorneys were so helpful in drawing up this contract. So they, yeah, let's talk to an attorney, talk to an attorney. And it's one of those things that we have to have a good script for advising our client, seek legal advice, or at some point in time, they're gonna say, gee, Bob, why not have you? Every time I turn around, you're sending me somewhere else. So we really need to have a good script. Yeah. So we need to have a good rationale, a good script for doing that. We'll see if I've got to do anything early. I've got one of my semi-annual or biannual or whatever cardiologist appointments. The good news is he's found that I do have a heart, which a lot of my don't agree, don't understand. I guess.
Yeah.
I'll probably hit it.
Yeah.
They never are. It's like.
My broker says that's the buyers.
Somebody else ready to buy.
Yeah, well, we can be allowed.
Yes.
She got out.
No,
What should I try to renegotiate? The first big.
John, I get maybe.
The one thing that I did learn, I totally forgot about.
Typically, close. It's using a loan as the usual. Oh, well, if it's cash, then the 3 days after that. That's only if you're getting this.
Everything else will be repaired. Not the shed, so I know it's the same.
so we got money for it, but you had to fix it.
Yes, and I do. And they, I'm sure they kind of. We want the shed even though that it was beat up.
So it could happen, it did.
Yeah. So that's the thing that.
That would be in our price range.
Pull it up on.
The shed would not be considered.
So we can look up the.
It's just on top of the ground, or is it actually part of?
It's just sitting on top of the something.
Not real, yeah, I don't. It's probably.
I'm so disappointed that this should have been a full house.
Yeah.
It's vacation time though.
Yeah, sure. Turn it off.
I'll turn it on for you.
You know what, Bob, you're better than any lawyer. Why do you have to go to
Your
lawyer?
language here.
No, you know so much. I mean, I really love lawyers.
Yeah, but I know I don't know what to do. I know my limitation, but thank you for being here.
Anything.
Well, because I worked on it for a really long time.
Oh, my